That's what happens when you're in a moving vehicle. You might lose your signal. Can you hear us?
Hello? Hello?
Yes, can you hear us?
Sure. I'm fine. Uh, turn my. It is. It is up. Let me see.
Okay, what happened? Okay, I don't know where he is anymore. I think we lost him.
He was supposed to have documents to me as of today, Your Honor. Why don't I just file a motion to show cause? That'll give him the time he needs to get these documents together, and we'll have a firm date to be back.
Cool.
And if he doesn't produce the documents, he can explain why he's refusing to comply with the court order.
I'm here.
Okay,
I'm here.
you can hear us?
Yes,
You can
I
hear
can.
us?
Yes, ma'am.
Okay, on the record in the matter of Lafkin versus Tyler Fundenbergs, this is 16-02083 GC. Can I have your appearance officially for the record, counsel?
For plaintiff Lapku, Tim Smith, P48259.
And then Mr. Fundenbergs, you are appearing virtually. You're not driving at
No, I'm
this moment.
pulled up to the side of the road. No, I'm pulled over now.
Okay, this was a control date that was set by the court because you were ordered by the court to turn over certain documents. My
Yeah,
understanding is that you have decided that you didn't want to turn those over.
no, that's not what happened, ma'am. I didn't do it because I didn't really understand it was for the judge. I thought it was for them. I get it turned in. I didn't know it was for
It's
you.
not,
I apologize.
no, it's not for me.
Yep.
It is for the plaintiff. However, it is ordered by the court because you owe money.
Okay. Okay, well, I'll get it in. I didn't. I apologize.
Okay.
I didn't.
When are you turning it over?
I'll get it turned in within the next week. I just got to get the documents around. I just saw I need my W-2. They said I don't, ma'am. I don't know. I don't know where my W-2s are. I don't know how to get them. I don't know where they at. I can get my check stubs for them if that'll do whatever they need. But my W-2s and my tax forms I haven't did in a couple years, and I don't know where my W-2s are at all.
You need to talk to Ashley at PJ's Towing, Tyler. I know who to talk to. Talk to Ashley.
Yeah, I know. You just got off the phone with them. I already know this.
Yep.
You should get your W-2s from your employer.
Yep. Okay. Get them. I'm sorry.
Turn those documents as ordered by the court so that the court doesn't have to take further action and sanction you. You just turn that over, sir.
Yes, ma'am. I absolutely will. You said I could just turn them into the court?
No, you're going to turn them to Mr. Smith. I don't necessarily need to see them, but if you make it difficult, then we'll have to take further intervention. Typically, these matters are handled without the court having to take personal intervention. So we want you to be compliant and just with Mr. Smith. Okay.
Okay. I will. So just get him in and then just start my payments or what, sir?
I want to make the record clear, Your Honor, in addition to the W-2 and the pay stubs, he's got 3 online banking relationships. These were part of the letter I sent him after the last hearing. He's got Cash App, Venmo, and PayPal and owes 6 months of monthly accounts. Tyler, stop.
I don't know. No, I'm gonna stop. I don't have those. You're not gonna tell me I got something.
No, you're gonna stop. You're gonna stop because I have a record that's being made, so we don't talk over each other. So I'll allow you an opportunity to respond when he's not talking, but I wouldn't allow him to talk over you, and I also am not gonna allow you to talk over him. Okay?
Okay.
On June 3rd, Your Honor, we did the creditor exam, and he testified that he utilizes Cash App, Venmo, and Apple Pay. He has no standard banking relationships, and there's a lot of under the table, pay by check, but there's money funneling through, according to his testimony, those 3 online banking relationships, and that subpoena would require the last 6 months of monthly account statements for Cash App, Venmo, and Apple Pay.
Not true.
Okay.
That's not true. So I don't know what he's talking about.
Okay, so you don't have Cash App, Venmo,
I have a, yes, ma'am, I have Cash App. I don't have Venmo or whatever the other one he said.
Okay.
Yeah.
Okay. So you turn over the ones that you do have, and then you'll, at the next date I'm going to give you, you'll meet with Mr. Smith, and hopefully you all can resolve this by understanding what your payment plan is going to be moving forward. And then we won't have to continue to investigate your finances this way, okay?
I thought we already had the payment plan agreed upon with the letter. It was $150 a month. I just don't understand how they want me to. I pay $1,000 in child support. I pay 3 other cars that I'm paying off right now for the same thing. Like I'll pay. I'm like, I don't have no problem paying them, but like I'm gonna have no money left. Like what more do they want?
Okay. Well, the court, you all have an installment payment order already?
Yeah, it's supposed to be $150 a month.
Your Honor, we don't. After the last hearing, we did an involuntary payment plan starting in June. He didn't send the June payment. He didn't send the July payment, but there's no order.
Got it. Okay, sounds good. All right, let me give them a new date so they can provide the documents and you all can move forward. Hopefully you all will come to an agreement. And sir, for your benefit, if you do come to an agreement, you should make it formal and not informal. It's called an installment payment order, okay, Mr. Fundenberg?
Okay.
And if you enter an installment payment order and you are consistent with that, that will prohibit them from being able to garnish any of your wages and things, okay?
Okay.
Well, give me this.
So when would I gotta have this stuff in, and where's my next court date?
I'm getting it right now, sir.
Okay. All right.
Yeah, September 12th at 2. Okay, you need to turn over those documents within the next 14 days, and your next court date is going to be September 12th at 2.
Okay.
Do you have any questions?
Nope, I don't. Thank you.
You're welcome. You're all set.
Yeah.
Bye. Okay. Was that all the matters for you today, Mr. Smith?
I think it was just the 3, Your Honor. Thanks for the help. I'm gonna bounce out of here.
Thank you.
You bet.
Objection to periodic payments. Do I got a live file? 22-0. Okay. Okay, so this is on the record in the matter of Sparrow Hospital versus Jet Kuka, 22-00686 GC. Appearance, please.
Good morning or afternoon, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Okay, Mr. Kuka, please remove your hat, please.
That's me.
State your name. State your name for the record, please.
My name is Jet Cuckoo.
Okay, today was the date that was scheduled for a hearing. This is for a motion or essentially an objection to garnishment. My understanding is that the parties did meet privately. Counsel, did you all resolve this?
Your Honor, we spoke. I explained to the defendant that his objection is essentially attacking the underlying judgment. And I did explain to him that's not a valid objection to the garnishment. If he wants to do that, there may be another route he could take. But at this point, we're just asking that the objection be denied.
Okay, I was hoping that maybe you all had discussed something further. Nonetheless, I see that his motion says that he's objecting to the garnishment under Section F. He believes that the garnishment was not properly issued.
Yes, ma'am.
And that's because you said that you were on your mother's insurance?
Yes, ma'am. So at the time, so what happened was I had went to I was working at this place. I'm a welder. So I was working at this place. I ended up getting sick from breathing in the stuff at work. So I had went to Sparrow, and then they ended up giving me care for it. And then that's pretty much the last thing I heard from it. And then I just, like, a couple weeks ago, I was working and my boss called me upstairs and said my check was starting to get garnished. So, like, I was just confused on how I got stuck with the bill, and the job I was working at didn't have to pay for it, nor it didn't get sent, like, deferred to my insurance that I was under. And I have the policy number and the insurance that I was under at the time.
Okay, so a couple of things, sir, because you filed an objection and you decided that it applies that the garnishment was invalid because it wasn't properly issued. What you're alleging, although may be true that you were under insurance at the time, that does not mean that the garnishment has been improperly issued. What you are alleging is that the judgment was improperly issued, not the garnishment. And under the court rule, it specifically states that you cannot use this challenge to object to the validity of the actual judgment. You need to take some other course of action. What I noticed as I'm reviewing your file is that you were served with a summons and complaint to which you never responded.
I personally don't remember getting served any papers.
Okay, I recognize that you don't personally remember. However, I have a proof of service here. The address on the proof of service is the same address on the notice of hearing for this objection today. I have no reason to believe that the proof of service, which indicates that they personally served you, they estimated you to be approximately 31 years of age, a male, white in color, 5'10", 195 pounds, with light brown hair, does not wear glasses, that you were served on May 4th, 2022 at the address on the file, which is still consistent today, at 6:51 p.m. I have no doubt that with all of that information that you were in fact served personally as indicated. And so when you are served, that summons and complaint gave you an instruction that you were supposed to respond or answer the complaint. And it says that you had 21 days after receiving the summons and complaint to file a written answer with the court and serve a copy on the other party, or you could have taken some other action. You filed nothing, and because you filed no response, the plaintiff was able to then go and request default judgment, meaning you have failed to enter the case and refute what they're saying, so they automatically win. Had you joined into the case at the time, according to the rule on the paperwork that you received, you could have simply wrote, this should be filed, this should have went through my insurance. I was covered by insurance. That would have been your answer and your defense at the time. You did not do that. Outside of that, there is a period of time that the court rules give you to make an appeal, even if, let's say, you forgot to respond or some other good cause occurred that required you or caused you to miss that 21-day deadline. If you had filed an appeal within that and provided the court with good cause as to why you missed the deadline and a meritorious defense, which sounds like you might have a meritorious defense, you could have then gotten the default set aside. But none of that has happened. And what we typically have is people ignore the fact that they're being sued civilly. And 99% of the time, once that garnishment comes in, we hear from them. It happens all the time. So unfortunately, you have not provided the court with any lawful basis where I can grant your request, although I do believe you have a meritorious defense. If you were covered by insurance, it should have went through your insurance.
Yes, ma'am.
I'm gonna deny the objection, but it's between you and Sparrow to try to see if you can work this out. Maybe they can go rerun it through your insurance and get the money and move on. I don't know, but you all should try to do that, okay?
Yes, ma'am.
Okay. With that being said, I'm going to see, did you want to go back in the private meeting room or are you going to speak offline, counsel?
We'll just reach out to defendant, Your Honor. Does the court need plaintiff to submit an order?
Yes, if you could submit an order, that would be great. Thank you.
Okay.
Any additional matters for the record?
No, Judge.
Thank you. You're all set for today.
Thank you.
Thank you.
Let's see. Portfolio recovery assets versus Keisha Pointer to 4-08309. Council appearance.
Good afternoon, Your Honor. Thomas Duquette, P82958, on behalf of the plaintiff.
Okay. Do we have Keisha Pointer at all? No, I didn't think so. Let's see what we have here. Okay, today was the date set for a motion for entry of judgment. Let me get the file open here. I don't know what that is. Let's see. Let's see, notes. Say motion for second summons. Am I in the right? Oh, let's see. Notice. Okay, council, did you file a motion for something? I only see a motion for second summons in here.
I don't think we filed a motion, Your Honor. I think we submitted the standard default judgment request. I think the court set it for hearing after we submitted that.
I see a proof of service that was filed on June 9th. Let's see. Okay, there's some notes here. Let's see. I think the issue was the amount of fees. The clerk flagged this file because the fees appeared to be excessive based on the GPS of the locations. I think that was what the issue was.
Our position on that, Your Honor.
GPS and photo fee seems to be excessive. Are these fees excessive? Okay. Can you explain the cost, please?
Sure. Our client requires GPS and photo fees for each service attempt. They do this to justify any potential motion for alt service. They also do it to address preemptively any challenge to service made by a defendant. So we think that all the fees are justified as the statute supports that each request by plaintiff is recoverable.
A GPS fee, what is that exactly?
A GPS location on the residence.
You're charging $20 because you use GPS?
Without knowing a bit more about the process, I can't offer the court a great explanation.
What is it? What is the $20 photo fee? What is that?
Photos of the residents are taken each time a service attempt is made. Then they're used subsequently to support each attempt on the affidavit.
Okay, and that's because you feel like you want to take photos to protect your claim that you made service? Is that why?
That's correct. Yes, it justifies each attempt.
Okay, and why is it costing $20 to take photos?
Again, Your Honor, I don't know exactly what goes into the process. I'd be happy to look into that a bit more and supplement something for the court, but I don't have a 100% accurate
I
answer
don't
for
think
you.
it's necessary, to be honest, because I'm pretty sure these photos are being taken with a cell phone. I think it's excessive and it's unreasonable, so it's denied. I'm not giving a photo fee. I'm not giving a GPS fee. If you want to resubmit your paperwork minus those, then I'll approve it.
Understood. We will do so. Thank you, Your Honor.
Thank you. You're all set. For the record, in the matter of Cheltenham Law versus James Burton, 25-01279, counsel appearance, please.
Good afternoon again, Your Honor. Thomas Duquette, P82958, behalf of the plaintiff.
Good afternoon, Your Honor. Ben Folger on behalf of James Burton, present on the Zoom. And if it also please the court, before we begin, I'd just like to briefly acknowledge the scholarship of our intern Talia Epps as well in our conference room.
Oh, greetings to your intern. And where's your intern studying?
I'm studying at Michigan State University.
Oh, look at my intern is also here from Michigan State University. So you all should connect and maybe discuss some of the things that you learned over the summer. So happy to have you with us here today. And I should say for the record that I remember Mr. Folger when he interned when I was at the city attorney's office. So welcome all today. So this is a motion for summary disposition. And my understanding is that the parties did meet privately before I called the case. Did you all come to any resolution on this?
No, we did not.
Okay, and so essentially, if you can help me summarize this, Mr. Duquette, there's a complaint alleging that the defendant owes your client at least $8,000 for some legal services.
That's correct. It's a collection action for legal services that my client provided defendant. The total amount that remained due and owing on the account was $9,268.39. There's no genuine issue of fact here that a retainer fee agreement was signed. It's attached as Exhibit A to the motion. There's also no question under the retainer fee agreement how payment was supposed to be made by defendant to my client. If you take a look at paragraph 5 of the agreement, it reads that after completion of the full retainer fee payment schedule is made totaling $8,000, client will pay invoices on the balance due listed in the invoice. Paragraph 8 then provides that if the retainer fee is completely depleted, the client will be billed monthly. If we take a look at Exhibit B.
Okay, give me just a second, because OnBase, these are uploaded individually and OnBase don't work that quickly. Let's see here. I'm on Exhibit B. Exhibit A again is the agreement, correct?
Correct.
Okay, you said paragraph 5. Let me scroll down. It says here, it does, I see that, let me first go over a little bit more. It goes over the retainer agreement. It says total retainer was of $8,000. It gave, I guess this is supposed to be a payment plan under paragraph 1. Is that correct?
That's correct. Paragraph 1 is the breakdown of the retainer fee payment schedule.
Got it. And then it does say in paragraph 5, if a balance is due and owing on a particular invoice, payment is due at the rate of $1,000 monthly until retainer fee is of $8,000 paid in full. After completion of the full retainer payment schedule is made totaling $8,000, client will pay invoices on balance due listed in invoice. So the allegation is that there was an $8,000 retainer, and that was paid, or for the most part was paid, and then there was another invoice after that?
Several invoices. If the court looks at paragraph 8 of the agreement, it reads that if the retainer fee is completely depleted, then client will be billed monthly. Then this is when I would draw the court's attention to Exhibit B. Exhibit B is the final invoice that was issued by my client to defendant. If the court looks at the bottom of page 2 of Exhibit B, the trust history breakdown showing the money that would have been paid under the retainer fee schedule is broken down there. It shows several deposits, several withdrawals, which were payments made towards the retainer fee schedule. But ultimately, it shows that as of October 13th, 2022, the trust was completely depleted. Defendant never put more money into that, never made it to the $8,000. From there, paragraph 8 of the agreement kicks in, and he began to be billed via monthly invoices. Invoices were sent to him at his current address. They were never objected to as they were received monthly. And that then kicks in paragraph 9 of the agreement. Paragraph 9 reads that the attorney, my client, may withdraw as counsel if more than 2 payments are missed or balance due is over $5,000 unless otherwise agreed upon between my client and the defendant. There was no other agreement. So my client had the right to withdraw. That's ultimately what happened. If the court then draws its attention back to Exhibit B, the final action taken in the case were all related to a motion to withdraw. So with all that, defendant was billed monthly invoices. He didn't pay them. He didn't object to the invoices on a monthly basis. And the total amount then became due and owing to my client. Now, here we are, this lawsuit 2-3 years later after it, and this is the first time that the defendant is attempting to voice objections to the amounts that are due and owing under the agreement. He's basing those objections on the effectiveness of my client. Now, 2-3 years later, for the first time in a defense to a lawsuit, isn't the time to voice those objections. It would have been as he was receiving these monthly statements. He didn't acquiesce to each invoice as he received, acquiesce to the final balance, and that's the balance that remains due and owing. That's the balance that we filed this lawsuit to collect on. Also attached to the motion as Exhibit C is our affidavit. The affidavit attests to the amount of damages that we're seeking to recover. Based on all these things, we think that we have set forth our case, which would shift the burden to the defendant to produce specific triable issues. Defendant can't do that. If you read through the response, he makes some claims about unpreparedness of my client, of potential poor representation, but he can't specifically set forth any triable issue as to any of these charges. And with that, there is no triable issue that should deny my client's right to recovery. Based on that, based on what we set forth in the brief, we'd ask the court to enter judgment.
Okay, so did your client demand another lump sum of $8,000?
I am not apprised to any such demand. What I know is the final invoice that was issued to the defendant is the amount that my client is seeking to recover. If we follow through the retainer fee agreement, that's not what would have happened. Defendant was to pay his retainer fee schedule. If and once he did, then payment was to be made on a monthly basis on each invoice that was issued.
Did you attach any other invoice other than this last one?
I don't believe so, Your Honor. I think we just have the final invoice. I understand that doesn't explain the balance forward that you see on the invoice. But again, these invoices were issued monthly, and each time defendant failed to object to an invoice, he acquiesced to the balance. And so we're of the position, the final invoice that sets forth the forwarded balance and the final charges on the account is sufficient to justify the amount we're seeking to recover.
Okay, thank you. Mr. Vogler, you can respond.
Thank you, Your Honor. As you just addressed and saw in my client's affidavit, the agreement was that he was going to pay $8,000. That's what he told the fee was going to be for this case. Prior to completing the fee agreement, as outlined by Brother Counsel in paragraph 5, she demanded another $8,000, which was referenced in the affidavit. Clearly a breach of the agreement here. If you look at the language in paragraph 5 compared to paragraph 8, they can't have it both ways, Your Honor. In very bold language, it says, quote, after the completion of the full retainer fee payment schedule is made totaling $8,000, then invoices will become due. Invoices could not become due because the retainer was not completed yet. They're arguing two things, as you're aware, Your Honor, under C9 and C10. Their C9 motion is completely absent from their brief here. They didn't address that. As you know, under C9, these are tested by reference to the party's pleadings. Since there's nothing there, I believe that motion should be denied. Our affirmative defenses were valid, and therefore this motion under that number should be denied. Regarding the C10, there is a genuine issue of material fact here, Your Honor. There's substantial differences in the demand for payment that was made in breach of the agreement. There was substandard work done, resulting in charges on the invoice well beyond what someone should charge. As you saw in the affidavit, Mr. Burton said that there were hearings he'd show up for that would have to be rescheduled because of the unpreparedness of plaintiff and ineffective work, and that was all at a cost to him. We don't have all the invoices, Your Honor. We have the last invoice. I would direct your attention to their Exhibit B. Brother Counsel says that the money my client paid is the trust. Well, that's the exact language. Trust trust deposit, but my client in his affidavit had paid over 7,000. So clearly there's some inaccuracies here. As you're aware, Your Honor, parties who breach first cannot maintain actions otherwise for breach of contract. And so our position here is that plaintiff breached first. There's several issues of material fact as to what was paid and what fees there actually are, and what, if anything, is due. So at this point, Your Honor, I believe that the court should deny the matter and allow for a full factual development to continue in the present case due to the poor work. Thank you.
Thank you. Okay, and I think my previous question was whether or not there was a demand. I don't think that the plaintiff is in the position to even answer that question at this time. He said he doesn't have any knowledge of it, but that doesn't mean that there was not a demand made by your client. And we have an affidavit, a sworn statement from the defendant that was a demand. I disagree with the plaintiff that there is no genuine issue of material fact that exists, because if the allegation is that your client breached first, well, then there's a question of fact as whether or not there was a breach on your client's part. And I recognize that Mr. Burton likely did not make any objection, at least that's your statement. He didn't make any objection or any inquiries into the requests or the statements prior to, but I don't know what those statements even were, or if those statements existed. The only statement that I have attached here was the final statement. And his affidavit indicates that he received a demand for another $8,000, which would not be in the clear language of the contract that he would have to pay another $8,000. So if in fact that was a request that took place before the completion of the initial $8,000, then that could be potentially a breach of contract there by your client. I don't know. The other issue is there's now a claim of some substandard work and some unpreparedness, which would be a breach of contract, because no one's contracting with an attorney who charges $400 an hour, paralegal at $200 an hour, for them to not be prepared for court and to do substandard work or to reschedule if that work, or if that it causes an initial or additional fees that are going to be on Mr. Burton's back. And so because of those reasons, the court do believe that issue of fact does exist, that's genuine. The motion for summary disposition is denied. Did someone provide me with a order already?
Thank you so much.
I can draft an order if you don't have one, Your Honor.
Okay, if you could provide an order through my file under the 7-day rule, I will review and sign it. And you all have already had a pretrial on, I believe, is that correct?
No, we submitted pretrial statements and that was canceled, Your Honor.
That's what okay. I did see during pretrial statement. So then, and are you requesting did you demand a jury trial?
I
did not.
did, Your Honor.
Okay, so we'll make sure this gets set for a trial date on the next available docket entry, and you will receive notice of that date in the mail. Oh wait, is there a proposed judgment? There might be a proposed judgment here already. Okay, I have a proposed judgment here. It's for order granting the motion for summary disposition. I'm going to alter it to deny. So no order needs to be provided. Any additional matters for today's record?
No.
None from defendant. Thank you, Your Honor.
Thank you. You're all set.
Thank you, Your Honor.
Thank you. Oh my goodness. This is the matter of Capital Village versus James Thomas, 25-02249.
John Adam Devlin, 272877 for the plaintiff.
Yes, hello?
You're James Thomas III, is that correct?
That is correct, yes.
Okay, give me just a moment where I open this file up. Okay, this is a motion to stop an eviction. The tenant filed this motion indicating that the property management is not honoring the agreement made with the court. Initially, on my first payment, the rental property told me my agreement is for $700. It says 2 weeks plus my monthly rent of, I can't understand that here, Ryan, is that $700, sir?
900, Your Honor.
$900. When that wasn't correct, I had to inform them it was only supposed to be $700 every 2 weeks.
Yes.
Which is $1,400 a month, not $2,400 a month. Now they're saying they aren't taking my payment on this past Friday when it's due. I came home from work on 7/18, had an eviction notice on the door. The payment wasn't even due until that day. Okay, let's see. There's an exhibit here. I see on July 8th, a payment of $650, and then there's a $50 money order, and I see a $700 on June 26th. See July 21st, $700 payment, or a check. Let's see what else is in here. It's like a money order receipt. Okay, so your tax and receipts. And was this a conditional dismissal?
Yes, it was a conditional dismissal, Your Honor.
Okay, it looks like it was signed by me on the 28th of May. Defendant shall pay $700 every 2 weeks starting June 6th until the balance is zero and current, including rent that comes due while this payment plan is in place. Okay, and so counsel, the allegations is that he did not pay his $700 every 2 weeks, or what is the issue?
Correct, Your Honor. The first payment was due June 6th. He made a $700 payment on June 9th. Next payment would have been due June 20th. He made that on the 26th. When the 4th of July came about and he didn't make the payment, my client turned off automatic payments, or turned off accepting payments from him, and requested the writ, which you signed.
Your Honor?
Give me just a moment, sir. I'll let you respond in just a moment.
Okay.
Okay, I'm looking at the affidavit that was filed in support of the request. It says the defendant wants to pay $700 every other week, starting June 6th until the balance into the, along with future rent that came due. It said defendant failed to pay on June or July 4th. What you're saying that he paid, but he paid late. Is that what?
I don't know if his payment, there's no payment after the July 26th payment on my ledger that I have from my client now. I don't know if he didn't come in or my client rejected it, but based off his failure to pay by July 4th, they're choosing that to go forward with the writ of eviction because he failed to honor the agreement. He was already late for the first two payments.
Okay, let me correct up to these receipts that we have. Sir, did you make a payment on the 6th of June? Well, let me fast forward. It said you failed to pay on July 4th. What happened there?
Well, that's the holiday weekend, I believe. When I went up to the office Friday, they were already closed early by the time I got out of work. The store supposed to was till 5, Your Honor. But when I got up there a little before 5, they already closed. So I paid it I came in the following week. I think that Tuesday to pay.
Is that the July 8th payment you're looking at?
Yeah, I paid last payment was July 8th, I believe. Or when I made my last payment on the 8th, you might be looking at that payment. I had confirmed with Michelle that I was still in good standing. So I came back in to make my other payment in 2 weeks from then. And they told me that they weren't taking.
So they accepted the July 8th payment?
Yes, and signed off on it. And she said I was in good standing as long as I make the rest of my payments.
No, I don't have proof of that payment. I don't have proof of her signing off of it. It's not contained within his motion.
Your Honor, if you look at the receipts, she signed off on it.
First of all, I'm looking at the receipt. That's how I'm looking at a MSU, FCU picture of a check as well as a Meyer receipt. It looks like for a money order for that date and time. Let's see. It says there's some language. It says M Nash paid. What does that mean, sir?
That's Michelle. That's the branch. That's the property manager that I've been in contact with this whole time talking to. That told me everything was all right.
But is that what you're saying, that M Nash was paid on those dates? I don't know what that means. That's what I'm asking you.
I just wanted, because they have been so shady with me, my interaction with them.
I need you to answer my question. I need you to answer my question. On the paperwork that you filed, it says M Nash paid. What does that mean? Who wrote that there?
The property manager.
Oh, she wrote that there?
Yeah, I was trying to explain to you, Your Honor. I wanted her to sign
Got it. Okay.
all of my stuff.
So that was filed. So counsel, I'm looking at it and it looks like it's her signature. If that's what she's saying, he says M Nash paid 6/26/2025. M Nash paid on July 9th, 2025. I see that there was.
I see that in his exhibit. Does he have any evidence that shows that check was cashed?
Well, are you saying that's not your client's?
That's not your client's signature? Your Honor, that's not a signature. That's just M Nash. I don't know if that's my client's signature.
Are you saying that's not your client's signature?
Your Honor, I don't know if it's my client's signature. My client emailed Monica Nash Michelle Nash is the property manager there, but I don't know if she signed it. The email I got from her today says that we haven't, because we had this motion file, or we had our application in writ order, that we haven't applied it to his account because we're seeking the writ. They're giving
that wasn't the question I asked. I want to know if M Nash, if that's her signing that, if she put that on here indicating that she was paid.
Your Honor, that's my client's name. I don't know if my client signed it.
Okay, well, your client could have been here for the purposes of today's hearing, and she's not here. He's testifying. He's testifying that she was paid and that she accepted payment and that she told him that he was in good standing. For those reasons, I'm going to grant his request to stop the eviction.
Understood, Your Honor.
Mr. Based on the information, I don't know why my phone is doing it.
Mr. Thomas, right?
Mr. Thomas, what you need to do, and I'm trying to pull up your original paperwork, because I'm confident that number 7 was selected. Let me double check. Number 7, which I go over when I put this on the record, is I indicate to you that partial performance will not satisfy this agreement. That means if you're supposed to make a payment on certain days, which is every 2 weeks, then you need to make those payments on those dates. Now, I see that you were supposed to make a payment on the 6th. And it looks like, I don't know, that was the 6th of June. I don't know if you made that payment on time. It looks like maybe for the first month, they were satisfied at minimum because they were accepting your payments. And then they decided that they want you to be in strict compliance. I don't know if you're paying on different days of the month. The 6th of June was a Friday. So it looks like your payments are supposed to come due on Friday. Is that what's going on? You're supposed to pay on the 6th. You were supposed to pay on the 20th. And then you were supposed to pay on the 4th.
That is correct, Your Honor. And
that is not the 26th. That is not the 9th.
But as I mentioned, Your Honor, the office hours, they don't honor the office hours. When I come up there, they're already closed at 4, sometime before 4. I don't.
Let me stop you. I'm looking at your check. They're dated for the 26th and the 9th. It wasn't that you had a check prior to that you appeared to have tried to tender. These are dated after the due date. The only reason why I'm granting you grace is because they were accepting it, and that you are representing to the court that they told you that you were in good standing. And I have reason to believe that because they were accepting those other payments, even though they were about a week late. But it's your responsibility to get it on the due date and not 6 days later. Otherwise, they have the right to request to have you evicted, and they don't have to give you a new court date. And I will not in the future be as lenient with granting such requests. And I'm sure if we have to go through this again, Mr. Devlin's going to have his client here to testify that you're not in good standing.
But why did she sign off on it though, Your Honor?
I'm not speaking. You're saying she signed off on it, and she's not here to say otherwise, so we don't know.
It's her signature.
Are you going to go back and forth with me, or are you going to listen to what I have to say?
Not at all.
So I said, you have said that she has signed off on it. Her attorney has not conceded that that is her signature, and she's not here, which is why another reason why I granted your request, because she's not here to say that's not my signature or anything otherwise. So I have no choice but to take what you're saying, that she said you were in good standing, that she signed off on it, and she accepted your payment. It said that you didn't make a payment on the 9th. It looks like you tried, was the 9th the week that the payment you were trying to make on the 18th? Is that the one that they wouldn't accept?
No, I made a payment. No, that's not the one, Your Honor.
No, the 9th was the payment that was supposed to be due on July 4th. And I can recognize that the office was not open on July 4th. So I can see that you wouldn't be able to make a payment. I feel like there should have been some grace given there. But for whatever reason, that was the week they decided your grace was going to run out. I'm going to give you the benefit of the doubt based on the statements that you said. I'm going to stop the eviction. You need to make your payments timely. You figure out from Ms. Nash or from Mr. Devlin what date they're going to be open so you can receive your payments, or they can receive your payments on time so you don't have to have this issue in the future, okay?
Okay, I have a question, Your Honor. So from here,
yes,
I continue with the 700 every 2 weeks from that time. I'm supposed to.
You need to be continuing with your payment plan, and I believe that you probably have a check that you haven't, that they did not accept. You need to catch up on that.
Okay.
So you need to give whatever was
two payments.
Yeah, so it looks like you owe a payment from the last 2 weeks, and then you owe a payment now. You need to make those payments immediately. Otherwise, it doesn't stay the eviction. You understand that?
No, let me clarify. I have to make $1,400 payment when? Right now? I don't understand.
Yeah, did you file a motion stating that they would not take your payment, the last payment?
Yes, ma'am.
Okay, so then you should still have that money then, correct?
That's $700.
Okay, and then since then, has another payment accrued?
Yes, Your
I'm
Honor.
pretty sure. Yes.
Mr. Devlin? Mr. Devlin,
Yes,
you
Your Honor.
say
He would have
something?
owed a $700 payment on the 18th of July and the 1st of August.
Okay, so yeah, you need to make both of those payments, sir.
Okay.
Okay, let me see, do I have a order on here? Okay, other than that, I'll enter an order consistent with what was stated on the record. Any additional matters for the record today?
No, Your Honor.
Thank you, you're all set. He's still there. Thomas, you can be removed. This is First American Auto versus Lexi Burns, 25-02230.
Good afternoon, Your Honor. Robert Zielinski on behalf of plaintiff, P69250.
Can you start your video, please? Counsel, I need you to start your video.
I see you and myself, Judge. I don't know what's going
on. It's Zelensky? Yeah. Okay, who is that song then?
Your Honor, I'm here for the Citibank versus Barry.
Okay, thank you. Okay, today was the date set for in this file for a pre-trial. My understanding is that the parties did meet in the breakout room. Did you come to a resolution or do a joint pre-trial statement?
We did come to a resolution, Your Honor. We've terms. We want to put them in the form of a consent judgment and email that. So I guess if we could adjourn the pretrial, if it all falls apart for some reason, maybe 45 days, but we did come to a resolution.
What is the resolution?
So the resolution is going to be a consent judgment for $7,758.12. That's inclusive of $115.35 in costs and $75 statutory attorney fee. It's going to have settlement terms where the defendant can settle the debt for $4,500, $2,500 due by August 30th to my office by a cashier's check. And then she's going to pay a minimum of $75 a month starting on September 1st. For the remainder, we are still, she's allowing us to file a state tax garnishment to use any of that money toward the settlement if there is a remaining settlement at the time we do get any funds next year.
Okay, and Ms. Burns, that is accurate as to how you want to proceed? Okay, you understand that you could have taken this matter to a trial and you have the right to be represented by an attorney? You want to waive both those rights? Okay, and so what he said as to the amount and the settlement agreement, all of that is what you're agreeing to? Do you have any questions? No. Okay, and would you give him permission to sign the paperwork consistent with what he just put on the court record on your behalf so that you don't have to come back to court to do this? Okay, so counsel, she's giving you permission to draft that and sign her signature on her behalf. You can file that on my file, and that way we do not have to reset this.
Okay, I'm still gonna email it to her first, Judge, just so she can read it if she has any questions before I sign her name. Yeah, but we'll get it,
That's completely fine, however you want to do that, but I'm doing that so that it doesn't have to further be on my docket. So I can just look forward to getting the paperwork, whether she signs it or you sign it.
Sounds good, Judge.
Okay, any additional matters for the record?
No, Your Honor.
Thank you, you're all set.
Thank you. Have a good.
Have a good one. Okay, Citibank versus Matthew Berry, 25-02773.
Good afternoon, Your Honor. Andrew Cates, P78292 for Citibank.
Good afternoon, Your Honor. Pamela Anderson, P40473 for the defendant.
Okay, today was the date that was scheduled for a pretrial. This is for a general civil matter. Did you all resolve this or come to a joint pretrial statement?
Your Honor, we weren't able to resolve it. We will be submitting a pretrial statement to the court. We were going to ask for 90 days of discovery in this matter.
Okay, yep, you would need to put that in the joint pretrial statement, both you sign it, I'll review it, and then that will kick out your scheduling order. If you do not provide the court with a joint pretrial statement within the next 7 business days, the clerk's office will trigger me to make a move on the case, to which I will just dismiss it for a failure to move forward, okay?
Thank you.
Thank you, Your Honor.
No problem, you're all set.
All right.
Thank you.
Have a good day.
Thank you.